I could hardly manage grocery costs, yet you expect this courtroom to accept that I can properly raise my grandson. My mother-in-law, Patricia Hale, declared this in a raised voice. My husband, Derek, remained seated next to her lawyer while Patricia held up pictures of my living space as though they proved neglect. I sat by myself, holding a file they believed held nothing of value. What Patricia failed to realize was that the judge had already spotted a figure hidden inside her financial statement. Half a year earlier, Derek had walked out after confessing his gambling habit. I had paid the rent he skipped, concealed his debts from Patricia, and sold my grandmother's bracelet just to keep our son, Noah, enrolled in preschool. When I declined to borrow more money, Derek shifted into Patricia's lakeside home and informed everyone that I had deserted him during a mental health emergency. Patricia had never valued my position as a pharmacy technician. In her view, my salary only confirmed I possessed no drive. She started showing up at Noah's school carrying gifts, informing the staff that she was the reliable parent. Afterward, Derek submitted a request for primary custody, asserting that my work hours and money situation rendered me unsuitable. Patricia offered to cover his lawyer fees if he signed a private contract granting her authority over Noah's education, medical choices, and living arrangements whenever Derek was not available. I learned of it because Derek mistakenly sent the unsigned version to our shared tax email. I chose not to confront him. I printed the document, altered every password, and began recording every detail. For a long time, I had handled our household paperwork because Derek despised forms. I knew which debts belonged to him and which payments Patricia made to settle his gambling losses. One transfer stood out, $12,000 from an account ending in 4419, marked Family Reserve. Patricia had declared under oath in her court papers that she possessed only one checking account and a modest retirement fund. My colleague Denise introduced me to her sister, a forensic bookkeeper, who showed me how to arrange records lawfully, dates, account numbers, emails, and original papers. She cautioned me never to touch anything that did not already belong to me. Therefore, I limited myself to shared tax files, joint statements, and messages Patricia had sent me directly. Then Noah returned from a weekend stay and asked why Grandma had told him he would soon enjoy a better mother's timetable. I smiled until he drifted off to sleep. Later, I sat on the kitchen floor gripping my grandmother's empty jewelry box, questioning how people I had shielded had twisted my sacrifices into proof against me. At the temporary hearing, Patricia's lawyer displayed my bank balance, apartment lease, and 3 late preschool pickups. He left out that 2 occurred because Derek never arrived on his scheduled days and the third took place while I covered an emergency shift. Patricia spoke next. She described herself as financially solid, retired, and prepared to supply whatever Noah required. She claimed Derek's gambling belonged to the distant past and charged me with inventing difficulties in order to dominate him. Her attorney smiled. They appeared near victory. Then Judge Marisol Vega raised Patricia's disclosure form. Mrs. Hale, what is the account ending in 4419? Patricia blinked. I do not recognize that number. I passed my folder to the clerk. Inside lay transfers from 4419 into Derek's account, followed hours later by payments to an online betting site. There were also emails from Patricia stating, "This is the final rescue and keep this from Lauren or she will use it against us." Derek at last looked toward me. Patricia recovered swiftly. She insisted the account belonged to a deceased cousin and that she only managed it. Her lawyer argued the funds had no connection to custody. Judge Vega requested the trust document. None existed. That was the moment I presented the second record. Patricia's text offering Derek $50,000 from the concealed account if he secured primary custody and allowed Noah to live at the lake house. She had written, once Lauren loses weekdays, she will accept whatever visitation we propose. Patricia turned to Derek. You claimed those messages had been erased. Her own statements finished what my evidence had started. Derek's attorney asked for a recess, yet Judge Vega denied it. Derek confessed the agreement was real and that his mother had covered his gambling debts throughout our marriage. He also admitted missing the preschool pickups and shifting the blame onto me. The judge denied Derek's custody petition, kept Noah primarily with me, ordered supervised visits until Derek entered treatment, and sent Patricia's false filing for further examination. Her hidden account was frozen pending investigation, including the money pledged as a reward for taking my child. Outside the courtroom, Patricia declared I had ruined the family. No, I replied. I prevented you from purchasing mine. Months afterward, Derek began counseling and gradually restored his bond with Noah. Patricia sold the lake house to settle tax penalties and legal expenses. I relocated to a larger apartment, not because any judge demanded it, but because I could finally budget without covering Derek's debts. I still grieved the family I once believed I had joined, yet Noah remained safe. My name stayed clear, and the records I had once kept quietly had safeguarded us both. Poverty was never my disgrace. Their conviction that my love could be purchased was.